My Lord Honourable Chief Justice, my Lords Honourable Judges, Honourable Justice M. Ramchandra Rao, Chief Justice of High Court of Jharkhand, Chairman of the Bar Council, Additional Solicitor General of India, Additional Advocates General, Deputy Solicitor General of India, Public Prosecutor, President of Telangana High Court Advocates Association, Justice Etirajulu, President Retired Judges Association, Registrars, Director of the Judicial Academy, President of the Telangana State Legal Services Authority, Secretary of Law and Legislative Affairs, Government of Telangana, family of late Sri Jagannadha Rao, respected senior members of the bar, friends. It is with a deep sense of loss that we gather here today to pay our final respects to Justice Mamidana Jagannadha Rao, whose contributions have left an indelible mark on our legal landscape. Justice Jagannadha Rao departed from this world in the early hours of November 25, 2024 in Hyderabad at the age of 89, just days before his birthday. His passing is not a mere personal loss for his family, but also a loss for the legal fraternity. Justice M. Jagannadha Rao was born on December 2, 1935 in Rajahmundry, then part of the Madras province, into a lineage adorned by legal luminaries. His father, Justice M.S. Ramchandra Rao, and his uncle, Justice M. Krishna Rao, served as beacons guiding him towards a life defined by discipline, integrity, and scholarship. He completed his schooling at Kesari High School and later completed his BSc Honours in Statistics from Presidency College, Madras. Although he briefly pursued advanced studies at the Indian Statistical Institute in Calcutta, he decided to dedicate himself to law, securing an LLB from Usmania University, Hyderabad in 1960. He was enrolled as an advocate with the Bar Council of Hyderabad on July 25, 1960. For the next 22 years, he practiced extensively on both original and appellate jurisdictions before the High Court of Andhra Pradesh. These formative years, spent under the mentorship of his uncle, molded his extraordinary intellect and cultivated his unwavering commitment to justice. As an advocate, Justice Jagannadha Rao had an extensive and successful practice, particularly in civil law and writ jurisdiction. Known for his in-depth knowledge, ethical conduct, and modesty, he was highly respected among the members of the bar. Justice Jagannadha Rao often charged moderate fees and was frequently engaged by junior lawyers to argue their cases. His practice reflected not just legal brilliance, but also empathy, encouragement, and accessibility. Recognizing these qualities, he was elevated as a Honourable Judge of the Andhra Pradesh High Court. Justice Jagannadha Rao was appointed as an additional judge of the Andhra Pradesh High Court on September 29, 1982, and on November 29, 1982, he was made a permanent judge. From the very outset, his judgments displayed not only profound legal erudition, but a pronounced sense of empathy, hallmarks that would define his illustrious journey on the bench. It was on August 8, 1991, that Justice Jagannadha Rao assumed the role of Chief Justice of Kerala High Court. In this capacity, he introduced critical administrative reforms and rendered judgments that engaged deeply with pressing legal and social questions. Subsequently, on April 12, 1994, he was transferred as Chief Justice of Delhi High Court, a period during which he enhanced the court's stature through astute leadership, fairness, and a vision firmly anchored in the rule of law. His time in Delhi, lasting until 1997, witnessed him earning the respect and admiration of both the bench and the bar, epitomizing that what Justice M.C. Chagla once remarked, true justice can never be repugnant to reason and moral sense. On March 21st, 1997, Justice Jagannadha Rao was elevated as Judge of the Honourable Supreme Court of India, where he retired on December 1st, 2000. In this august role, he authored landmark decisions and enriched the fabric of our jurisprudence and upheld the highest ideals of constitutional governance. Notable cases presided over by Justice Jagannadha Rao are many. However, I shall refer to some to show the commitment he held towards the profession and the office of the judge he held with aplomb. In Sada versus Tehsildar Utnur, reported in 1987 to APLJ 397, a landmark judgment was delivered by the full bench of the Andhra Pradesh High Court, comprising Justice K. Bhaskaran, Chief Justice, then Justice M. Jagannadha Rao, and Justice Syed Shah Muhammad Qadri. With the opinion authored by Justice M. Jagannadha Rao, the case revolved around the interpretation of Section 38E of the Andhra Pradesh Telangana Tenancy and Agricultural Lands Act 1950 and its amendments, particularly regarding the rights of protected tenants to ownership certificates and the conditions under which such rights would be exercised. The case emerged due to conflicting decisions from earlier division benches in Chinnaboyina Narsaya versus Tehsildar. The court held that physical possession by the protected tenant on the date of notification under Section 38E was mandatory for acquiring ownership rights. Conversely, in Chennai versus State of AP, a different division bench upheld the validity of ownership certificates issued even to tenants out of possession, provided certain statutory conditions were satisfied. This conflict necessitated a reference to a full bench for resolution. Justice M. Jagannadha Rao meticulously analyzed the legislative history and the scheme of the Act. He noted that Section 38E was introduced to enable the statutory transfer of ownership to protected tenants. The provision aimed to safeguard tenants who had cultivated land continuously but lacked formal ownership due to historical inequities. The 1979 amendment clarified that a tenant's absence from physical possession at the time of notification did not invalidate their ownership claim if they retained the legal status of a protected tenant. Justice Jagannadha Rao emphasized that the statutory framework, including the deeming provisions under the explanation to 38E, reflected the legislature's intent to prioritize legal status over physical possession. This decision, authored by Justice M. Jagannadha Rao, exemplified his legal acumen and deep understanding of social justice principles. By harmonizing the conflicting interpretation and affirming the rights of the tenant farmers, he significantly advanced tenancy jurisprudence. His ability to synthesize complex legislative histories and provide clear, equitable solutions highlighted his exceptional judicial craftsmanship, combining legal rigor and a profound sense of justice. The full bench judgment of our court has been quoted with approval and relied in many judgments of the Honourable Supreme Court in tenancy cases, not only from Telangana, but also from other states, as similar provision for the protection of agricultural tenants are there in most states. I once, briefing the former Chief Justice of India, Sri U.U. Lalit, before his elevation to the bench in a tenancy matter, he said, if your case satisfies the requirements of Sada, then you win your case. He said, Sada is a treatise on agriculture tenancy laws. Such was the contribution of the great judge to agrarian reforms. In Bhagwan Das versus Muhammad Arif 1987 SCC Online AP, this judgment was authored by Justice M. Jagannadha Rao as a judge of the High Court of AP, which stands as a cornerstone in Indian compensation law under the Motor Vehicles Act 1939. The case arose from a tragic accident on July 30th, 1978, where the respondent, a 35-year-old technician in the Merchant Navy, suffered the amputation of his right leg below the knee. The accident occurred due to the negligence of the appellant, the owner of a motor vehicle. The motor vehicle claims tribunal awarded 1 lakh in compensation. Dissatisfied with the award, the appellant challenged the calculation as excessive, while the respondent contended that the compensation failed to adequately consider future allowances, pain and suffering. Justice M. Jagannadha Rao meticulously analyzed the principles governing compensation for pecuniary loss and emphasized the concept of full and fair compensation. Drawing from established principles in Livingstone versus Raywords Coal Company, he underscored the importance of ensuring that claimants are placed in a position as close as possible to their pre-accident status. Justice Jagannadha Rao noted that outdated methods such as the lump sum approach were inadequate for addressing the complexity of future loss calculations. Instead, he advanced for the multiplier method. This judgment has become the basis for future judgments, including the Honourable Supreme Court. The judgment is also a testament to Justice M. Jagannadha Rao's profound understanding of law, economics, statistics, and human suffering. By integrating legal reasoning with mathematical precision, he laid a foundation for modern compensation jurisprudence in India. His efforts ensured that victims of negligence would be adequately compensated in a fair and uniform manner. Justice Jagannadha Rao's work in this case epitomizes his broader legacy of advancing jurisprudence with vision, scientific rigor, and a deep sense of justice. In the case of AP Pollution Control Board versus Professor M.V. Naidu, reported in 2002 SEC 62, which was decided by a bench of Justice M. Jagannadha Rao and Justice M.B. Shah. Justice Jagannadha Rao authoring the judgment, the case addressed the critical environmental conflict arising from the establishment of polluting industries near the Usman Sagar and Himayat Sagar reservoirs in Andhra Pradesh, which supplied drinking water to the twin cities of Hyderabad and Secunderabad. It dealt with the scope of the precautionary principle, the right to clean water under Article 21, and the validity of exemptions granted by the state under GO 153 in violation of earlier prohibitions under GO 111. This is Jagannadha Rao held that precautionary principle is central to environmental governance. He emphasized that when there is scientific uncertainty about environmental risks, precaution must prevail. The court unequivocally held that the state cannot grant exemptions under prohibitory orders like GO 111. As such, actions compromise the right to clean drinking water, which is protected under Article 21 of the Constitution. The court observed that GO 153 lacked statutory backing and it amounted to an abuse of power. The exemption was declared wholly arbitrary and unconstitutional. Justice Jagannadha Rao further elaborated on the burden of proof principle in environmental jurisprudence in this case, holding that industries seeking exemptions must prove beyond reasonable doubt that the operations pose no environmental risk. In this case, the seventh respondent failed to discharge this burden as their reliance on an outdated assurances and technology lacked credibility. In Chellamma, Kamalamma and others versus Narayana Pillai Prabhakaran Nair, when his lordship was Chief Justice of Kerala High Court, this case pertains to matriarchal lineage compared to the more known form of patriarchy. The judgment was delivered by a bench of 5 judges of the Kerala High Court, presided over by Justice M. Jagannadha Rao, Chief Justice, along with Justice K. N. Nair, Justice K. V. Ramakrishnan, Justice P. Krishnamurthy, and Justice K. P. Balanarayan Marar. Justice Jagannadha Rao authored the judgment on behalf of the bench. The case primarily dealt with the continued application of Section 17 of the Hindu Succession Act 1956, following the enactment of the Kerala Joint Family System Abolition Act 1975. The dispute arose upon the death of Lakshmi Kutti Amma, a member of a Nair family who passed away intestate on 18/2/82. Her husband, the plaintiff, claimed succession to her properties under Section 50 of the Hindu Succession Act, arguing that Section 17, which pertained to females governed by the Murmukkutayam law, had become inoperative post 1975 due to the Joint Family Abolition Act. In contrast, the defendants, her maternal relatives, contended that Section 17 continued to apply and vested the succession rights in Lakshmi Kutti Amma's mother, Chellamma, who subsequently passed away on 8/9/82. The Murmukkutayam law, prevalent primarily among Nair families and other matrilineal communities in Kerala was a system of inheritance and family organization where property devolved through the female line. Under this system, a person's heirs were their maternal relatives, particularly their mothers, sister, and their descendants. The Hindu Succession Act 1956, while codifying inheritance law, included Section 17, which provided special rules of succession for females who were governed by the Murmukkutayam or Aliyasantana laws. This Jagannadha Rao, speaking for the majority, held that Section 17 of the Hindu Succession Act had not been repealed either expressly or impliedly by the Family Abolition Act, Joint Family Abolition Act. The Honourable Court reasoned that Section 17 applied to a defined group of persons governed by the Murmukkutayam law as of the commencement of the Hindu Succession Act. The subsequent repeal of Murmukkutayam law did not affect the operation of Section 17 for individuals who fell within this identified group. Consequently, the court ruled that the succession to Lakshmi Amma's Kutti properties were governed by Section 17 and her mother, Chellamma, was entitled to inherit the property, not the plaintiff. The larger bench clarified that the Joint Family Abolition Act was not intended to interfere with succession laws under the Hindu Succession Act 1956. The judgment overruled contrary observations in earlier cases and affirmed the decisions in favor of the matriarchal system of inheritance. While in the Supreme Court, Justice Jagannadha Rao was part of many judgments. One of the notable judgments was Ajit Singh versus State of Punjab, reported in 1997 7 SCC 209, which was decided by a 5-judge constitution bench comprising A.S. Anand, Chief Justice K. Venkatramani, Justice G.B. Patnaik, Justice S.P. Kurdurkar, and Justice M. Jagannadha Rao. Justice M. Jagannadha Rao authored the judgment on behalf of the bench. Justice Jagannadha Rao, delivering the judgment, held that the catch-up rule laid down in Veerpal Singh and Ajit Singh Januja was correct, while Jagdish Lal was wrongly decided. He observed that the seniority rule based on continuous officiation would not be delinked from the principle of equal opportunity for promotion, which is a facet of Article 16(1). The judgment struck a critical balance between protecting the interest of reserved category candidates and safeguarding the constitutional rights of general category candidates. The court provided detailed guidelines for modifying seniority lists and clarified the prospective application of the decision in R.K. Sabharwal versus State of Punjab. The court also overruled Jagdish Lal and Ashok Kumar Gupta, State of UP, to the extent they conflicted with the principles laid down in this case. In Indira Sahani 2 versus Union of India, reported in 2000 volume 1 SCC 168, which was decided by a 3-judge bench of the Supreme Court comprising Justice M. Jagannadha Rao, Justice D.P. Wadhwa, and Justice M.B. Shah. Justice Jagannadha Rao had authored the judgment. The case addressed the critical constitutional issue of excluding the creamy layer from reservations for backward classes and evaluated the constitutional validity of the Kerala state backward classes reservations of appointments or to posts in the services under the state. The facts arose from the failure of the state of Kerala to implement the directions in the earlier 9-judge bench decision Indira Sahani versus Union of India, 1992, Supplement 3 SCC 217, insofar as creamy layer was concerned. Indira Sahani 1 was authored by Justice B.P. Jeevan Reddy for the 9-judge bench, and Indira Sahani 2 was authored by his close friend and co-judge Justice M. Jagannadha Rao after 7 years. We at the bar remember the days when Justice B.P. Jeevan Reddy and Justice M. Jagannadha Rao used to be a division bench for long period, and their intellectual affinity on the bench was apparent to the bar. This landmark judgment, Indira Sahani, had mandated identifying and excluding the creamy layer within backward classes from availing reservations under Article 16(4). Despite these clear directives, the state of Kerala enacted the 1995 Act, which declared retroactively that no creamy layer existed and that backward classes were inadequately represented. The Act was challenged on the ground that it violated Article 14 and 16 of the Constitution and undermined the basic structure of equality. Justice M. Jagannadha Rao meticulously analyzed the constitutional principles enshrined in Article 14, 16.1 and 16.4. He emphasized that equality is a basic feature of the Constitution and that reservation policies must balance social justice with the principle of equality of opportunity. The court reaffirmed that creamy layer candidates who have received a higher level of social, economic, and educational advancement must be excluded to ensure that the truly backward sections benefit from reservation policies. To remedy the situation, the Honourable Court accepted the Justice K.J. Joseph Committee report, which had identified the creamy layer in Kerala's backward classes. Justice Jagannadha Rao applied the principle of prospective overruling, directing that the exclusion of the creamy layer take effect from the date of judgment, that is 13 December 1999. He underscored that failure to exclude the creamy layer would result in reverse discrimination, depriving the truly backward sections of their constitutional entitlements. In BKSR Iyengar versus Central Public Information Officer, Archaeological Survey of India, reported in 2018 SEC Online, Central Information Commission's report, which was heard by Professor Sridhar Acharyalu as Chief Information Commissioner. The appeal concerned the RTI application seeking action taken for declaring the Tirumala Tirupati Devasthanam's temples as National Heritage Monuments under the Asian Monuments and Archaeological Sites and Remains Act. Central to the dispute was the demolition of the historic Veyyikala Mandapam, 1000-pillar temple, built in 1464 by the Vijayanagara Emperor Saluva Malladevara. The appellant alleged that TTD unlawfully demolished this heritage structure without consulting the ASI, violating archaeological norms. The appellant further emphasized the importance of the temple structures dating over 1500 years and the failure of the TTD to protect these as ancient monuments under statutory provisions. The Commission strongly criticized both the ASI and the TTD for their failure to protect these cultural heritage. Justice M. Jagannadha Rao's earlier report on TDD jewelry protection was referred during the proceedings. Justice Jagannadha Rao in his recommendations highlighted the need for transparent and foolproof systems to preserve and protect historical treasures, including ornaments donated by the Vijayanagara rulers, which remain unaccounted for in official records. Justice Jagannadha Rao, along with former Judge Justice D.P. Wadhwa in 2011, were appointed to a committee tasked with verifying the ornaments of Lord Venkateshwara in Tirumala and other temples managed by Tirumala Tirupati Devasthana. The committee meticulously examined the systems in place for safeguarding these sacred items. In May 2012, they submitted a report confirming that no ornaments had been lost and expressed satisfaction with the protective measures and maintenance protocols in place. Justice M. Jagannadha Rao had a pivotal contribution to the jurisprudence of administrative law through his judgments in Union of India versus Ganayutham and Omkar versus Union of India. These judgments, these landmark rulings clarified the principle of proportionality and its interplay with the Wednesbury principle, providing a comprehensive framework for judicial review in administrative matters. Justice Jagannadha Rao further emphasized the distinction between cases involving fundamental freedoms and those concerning other administrative actions. He noted that when administrative decisions affect fundamental rights under Article 19 and 21, the courts adopt the principle of proportionality and assume a primary role in reviewing the reasonableness of such actions. In these scenarios, the courts assess whether the means employed by the administration are proportionate to the objectives sought to be achieved, ensuring that the rights of individuals are not disproportionately impacted. This nuanced framework was further elaborated in Om Kumar, where Justice Jagannadha Rao refined the application of proportionality in judicial review. He highlighted that when administrative action is challenged under 14 for discrimination, courts apply proportionality as a primary review mechanism. However, in cases alleging arbitrariness under Article 14, the Wednesbury test continues to apply, restricting the courts to a secondary role. Justice Jagannadha Rao explained that this approach balances the need for judicial restraint in administrative matters with the imperative to protect constitutional rights. This is Jagannadha Rao's finding and observations in Union of India versus Ganayutham were also cited in the landmark 5-judge judgment of Sahara Banu versus Union of India, the triple test case. In the case of Salem Advocate Bar Association versus Union of India, decided by a 3-judge bench of Y.K. Sabharwal, Justice D.M. Dharmadhikari and Justice Tarun Chatterjee. While Justice Jagannadha Rao was not a part of the bench, his pivotal role as a chairman of the Law Commission and as the head of the committee constituted to address the functioning of the amended Civil Procedure Code was extensively referred in this judgment. Justice Jagannadha Rao's contribution through detailed reports paved the way for refining and operationalizing the 1990 and 2002 Civil Procedure Code amendments, ensuring access to speedy, efficient, and alternative dispute resolution mechanisms. The case arose after the constitutional validity of the Civil Procedure Code amendments were upheld in the earlier decision of Salem Advocate Bar Association 1. While upholding the validity, the Supreme Court acknowledged the practical challenges in implementing Section 89 CPC, which mandated courts to refer cases for alternate dispute resolution when there existed a possibility of settlement. Consequently, the Honourable Court constituted a committee chaired by Justice M. Jagannadha Rao, who was then serving as the chairman of the 17th Law Commission of India to formulate the modalities and framework for implementing these amendments. Justice Jagannadha Rao's committee produced a comprehensive report divided into 3 parts. 1. Addressing grievances regarding the CPC amendments. 2. Drafting model ADR rules, including guidelines for mediation and conciliation under Section 89 CPC. Developing a conceptual case management system to ensure judicial efficiency. The Supreme Court in this judgment approved Justice Jagannadha Rao's model ADR rules, emphasizing that Section 89 CPC was mandatory in nature. It clarified that courts shall formulate terms of settlement and direct parties to opt for ADR methods, arbitration, conciliation, judicial settlement, and mediation wherever possible. This Jagannadha Rao's recommendations provided clarity on the procedural aspects, balancing judicial discretion and the need for effective dispute resolution. The committee also drafted rules to ensure fairness and uniformity in the ADR process, which the court directed all high courts to adopt within a specified time frame. Another significant aspect of Justice Jagannadha Rao's contribution was his focus on case flow management and judicial accountability. His recommendations as the Law Commission Chairman introduced practical frameworks for fixing realistic costs in litigation to deter frivolous cases, streamlining witness examination procedures, introducing a structured timeline for case hearings to promote judicial efficiency. The Honourable Court endorsed Justice Jagannadha Rao's recommendation regarding affidavit-based examination in chief under Order 18, Rule 4 CPC, clarifying that it expedited trials without compromising the cross-examination process. Justice Jagannadha Rao's insight also addressed concerns about the affordability of ADR mechanisms, proposing that courts ensure minimal financial burdens for litigants opting for mediation or conciliation. This judgment reflects Justice Mr. M. Jagannadha Rao's monumental contributions to as the architect of post-amendment CPC implementation. His reports formed the cornerstone for establishing a robust, accessible, and efficient judicial framework that harmonized formal adjudication with alternate dispute resolution mechanisms. The court's endorsement of Justice Jagannadha Rao's vision underscored his legacy as a jurist deeply committed to judicial reform, efficiency, and justice for the common litigant. Even after his formal retirement from the bench, Justice Jagannadha Rao continued to serve the law and society at large. He brought his intellectual rigor and reformist zeal to the Law Commission of India, serving as Vice Chairman of the 16th Law Commission from 2002 to 2003 and as Chairman of the 17th Law Commission from 2003 to 2006. The Salem Bar Association and other judgments referred to the reports during this period in great detail. Under his stewardship, the Commission submitted 26 reports that addressed wide-ranging issues like witness protection programs, trial by media, medical treatment for the terminally ill, and reforms to the Contempt of Courts Act 1971, among others. Each recommendation reflected his deep understanding of the evolving needs of society and the justice delivery system. Justice Jagannatha Rao's scholarly commitment also encompassed alternate dispute resolution mechanisms, transnational litigation, and the law of limitation, these areas where his works remains a benchmark. He served as a member of the arbitral panels in two prestigious international commercial arbitrations, one in Geneva and another in London, reflecting his global standing as a jurist. Additionally, he was also part of several three-member domestic arbitral tribunals that included other retired judges of the Supreme Court and High Courts, and he frequently served as a sole arbitrator in domestic arbitration matters, demonstrating his expertise in dispute resolution. It is said that the true measure of a jurist lies in the legacy he leaves behind, both in the courtroom and the institutions nurtured. In December 2000, Justice Jagannatha Rao joined the subcommittee of the National Commission for Review of the Constitution also. Beyond his contribution to judicial reforms, Justice Jagannatha Rao was also an eminent academic figure as a special professor at Nalsar University of Law and a member of the academic councils of renowned law institutions in Bangalore, Jodhpur, and at the Indian Law Institute, New Delhi. He played a pivotal role in shaping legal curricula and pedagogy. He chaired the academic council at the Army Institute of Law in Chandigarh and remained an active participant at the National Judicial Academy, steadfast in his belief that continuous learning and training are indispensable to the vitality of the judiciary. Justice Jagannatha Rao was also a member of the board of Truth Labs, a private forensic laboratory, where he contributed to advancement in forensic sciences and their application in legal proceedings. Justice Jagannatha Rao also served as a member of the board of the C.R. Rao Advanced Institute of Mathematics, Statistics, and Computer Science in Hyderabad, contributing to interdisciplinary education. Justice Jagannatha Rao, apart from his colossal contribution to the Indian jurisprudence, also wrote an artistic article in the book Supreme but Not Infallible, published in 2000. This book is a collection of essays in honor of the Supreme Court of India. This book is meticulously edited by Justice B.N. Kirpal, former Judge of the Supreme Court of India, Ashok Desai, former Attorney General of India, Gopal Subramaniam, former Solicitor General of India, Rajiv Dhawan and Raju Ramchandran, senior counsels. Justice Jagannatha Rao's contribution to this book was the article, The Goddess of Justice, the Constitution and the Supreme Court. It is a thorough study on the iconology of various pictures, symbols, which adorn the various places in the Supreme Court building. However, the major portion of the article is dedicated to the study of the statue of the Goddess of Justice. The Honourable Supreme Court of India on October 16, 2024 unveiled a reimagined statue of Lady Justice in its Judges Library, commissioned under the guidance of the former Chief Justice of India, Dr. D.Y. Chandrachud. This new depiction discards the traditional blindfold to symbolize that justice in India is not blind, but aware, transparent, and attuned to the realities of those it serves. Instead of a sword, Lady Justice now holds a copy of the Indian Constitution, underscoring that the source of true justice lies in constitutional principles rather than punitive measures. This transformation resonates deeply with the vision of jurists like Justice Jagannatha Rao, who believed in a system of justice that is both principled and culturally grounded. Justice Jagannatha Rao's personal life was marked by devotion both to his family and to the ideals of knowledge and service. His wife, late AVLN Sharada Devi, served as an MD pathologist at Usmania and Gandhi hospitals. She later became the head of the department at Sarojini Devi Eye Hospital and retired upon attaining the age of superannuation. She passed away in 2015, leaving behind a legacy of medical service and dedication that complemented Justice Jagannatha Rao's own public life. He is survived by his siblings, his brother Sri Krishnamohan Rao, a practicing advocate, and his sister Srimati Nirmala Devi, a devoted homemaker. Justice Jagannadha Rao is survived by his 3 children, each of whom continue to bear witness to his enduring legacy. His son, Hon'ble Justice M. Ramchandra Rao, currently serves as the Honourable Chief Justice of the Jharkhand High Court at Ranchi, carrying forward his father's mission with dignity and distinction. Justice M. Ramchandra Rao is married to Dr. Eva Saroj, PhD, and they are proud parents to twin daughters, Ananya and Nandana, aged 10 years. Justice Jagannadha Rao's elder daughter, Srimati Ratna Manjari, a gold medalist in pure mathematics, has earned accolades for her academic brilliance with an MSc in mathematics. Married to Sri G. Ramana, an architect, they have 2 accomplished daughters, Srimati Gautami, a BTech graduate from IIT Guwahati, currently working with Amazon in Amsterdam, and married to Sri Devanshu Bhimwal, an alumnus of IIT Kanpur and her colleague at Amazon. Dr. Maitreyi, MDS, who serves at Usmania Dental Hospital in Hyderabad. Justice Jagannadha Rao's younger daughter, Srimati Rama Devi, is a software engineer, holding a senior position at Microsoft in the USA, and is married to V. Sudhakar, a software engineer at Oracle Corporation, USA. They have 2 children, Sanjana, and a biotechnology graduate at Tufts University, USA, and Sachit, currently pursuing his graduation at Bowdoin College, Brunswick, Maine. In this way, the flame of a noble legacy continues to burn brightly, a living tribute to Mr. Jagannadha Rao's lifelong pursuit of justice, righteousness, and excellence. He was also very empathetic to the young lawyers. He was a very composed judge who never lost his cool in court. I can definitely say that the younger bar, which did not appear before Justice Jagannadha Rao, have been denied a great experience because of their age. He used to advise junior counsels from the bench and off the bench. One of the incidents which I can narrate from my personal experience is, on his elevation as the Chief Justice of Kerala, where the customary farewell was given at the High Courts Association, he very worriedly said in as many words, "I see so many young lawyers in the profession. I am worried about them as to how they will make a living in this profession." He also had a very humorous side. In the same farewell, he said, "An advocate should also learn to claim his fees." Referring to his experiences as a lawyer, he said that clients who come from the business community, they give half your fee first and the remaining half at the time of final hearing, and that too in small denominations so that the advocate feels the weight of the fee. Justice M. Jagannadha Rao was not merely a jurist and a reformer. He was, one might say, a true Nyaya Panditudu. A blend of humanity, scholarship, and clarity, evident in his writings, judgments, and law commission reports, stands as a testament to his remarkable intellect and moral compass. Justice M. Jagannadha Rao's personal life was an embodiment of humility, integrity, and generosity. He was deeply committed to serving society, donating to charities, and guiding individuals in distress, irrespective of caste, creed, or color. A principled and pious man, he rejected ritualism, focusing instead on meaningful actions that uplifted those around him. His life serves as an enduring inspiration for future generations. In Justice M. Jagannadha Rao, we have lost a towering personality who personified integrity, reformist foresight, and profound compassion. As we mourn his passing, we also celebrate a life in service of higher ideals. On behalf of the entire legal fraternity, I extend our deepest condolences to the bereaved family, friends, association, and all who came across the noble soul. May we find solace in knowing that his spirit endures in the corridors of justice he helped shape, inspiring generations to come to follow the path he so nobly charted. May his soul rest in peace.
My esteemed colleagues on the bench, Brother Justice M.S. Sri Ramchandra Rao, Chief Justice of High Court of Jharkhand, Mr. B. Narsim Sharma, Additional Solicitor General of India, Mr. A. Sudarshan Reddy, Advocate General Mr. A. Ravinder Reddy, President Telangana High Court Advocates Association, Mr. A. Narsim Reddy, Chairman Bar Council of Telangana, Mr. P. N. Rao, Public Prosecutor, Dr. Justice G. Yeti Rajulu, President Retired Judges Association, learned senior advocates and members of the bar, Registrar and staff members of the High Court, Law Secretary, Member Secretary, Legal Services Authority, family members of late Justice M. Jagannadha Rao. We have assembled here to pay tribute to late Sri Justice M. Jagannadha Rao, former Judge of Supreme Court of India, former Chief Justice of Kerala and Delhi High Courts, and former Judge of erstwhile High Court of Andhra Pradesh. He left for his heavenly abode on 25th November 2024 at Hyderabad. Late Justice Jagannadha Rao was born on 2nd of December 1935 to late Justice M.S. Ramchandra Rao and late Srimati Shakuntala at Raja Mandri in East Godavari district. His father, late Sri Justice M.S. Ramchandra Rao, served as Judge of Andhra Pradesh High Court from 17th October 1960 to 23rd February 1961. His paternal uncle, Sri Justice M. Ramakrishna Rao, also served as a judge of erstwhile Andhra Pradesh High Court from 11th of July 1996 to 21st of August 1973. Late Justice Rao had his early education in Madras. He acquired a bachelor's degree in science from Presidency College Madras. Thereafter, he secured a bachelor's degree in law in 1960 from Osmania University. Late Justice Rao was enrolled as an advocate on 25th of July 1960 and worked as an apprentice under his father, who was a senior lawyer in the erstwhile Andhra Pradesh High Court. Late Justice Sri Rao had a large practice as a lawyer on civil side and in writ jurisdiction. He was known for his in-depth knowledge of civil and constitutional laws. Late Justice Rao was a soft-spoken lawyer who charged moderate fees and practiced ethically and fairly. He was highly respected by the members of the bar and was engaged by several junior lawyers to argue their cases. Late Justice Rao's brilliance and legal acumen was soon recognized, and he was elevated as judge of this court on 29th September 1982. During his tenure as a judge of Andhra Pradesh High Court, he authored several landmark judgments to which learned Advocate General has made a reference in detail. Late Justice Rao rendered distinguished service as judge in Andhra Pradesh High Court and was elevated on 8th of August 1991 as Chief Justice of Kerala High Court. Thereafter, he was transferred to Delhi High Court and on 21st March 1997 was elevated as Judge of the Supreme Court. As Judge of Supreme Court of India, late Justice Jagannadha Rao delivered several landmark decisions. Late Justice Rao authored the judgment of Constitution Bench of Supreme Court in Ajit Singh 2, wherein the ratio of decision of Supreme Court in Indira Sahni's case was explained. After superannuation, late Justice Rao was appointed as member of subcommittee which was headed by Justice Krishna Iyer, which prepared a consultation paper on enlargement of fundamental rights. He also served as chairman of 17th Law Commission of India from 2003 to 2006 and submitted 25 reports on various legal issues of contemporary relevance. Late Justice Rao was a member of academic councils of National Law University, Bangalore, Jodhpur and Indian Law Institute, New Delhi. He was also chairman of Academic Council of Army Law Institute, Chandigarh, and the chairman of Second Pay Revision Commission for Executives and Non-Unionized Supervisors of the Central Public Service Enterprises, which had submitted recommendations to the government which were implemented. Late Justice Rao attended Commonwealth Law conferences in Melbourne in 2003 and in London in 2005. He was a member of arbitration panels in 2 international commercial arbitrations, one at Geneva and another one at London. Late Justice Rao led a principled life and never deviated from the path of honesty and integrity. He was pious and helped people in distress by donations and guidance. With the demise of late Justice Jagannadha Rao, we have lost a multifaceted person who excelled in every role he played as a father, as a judge, as a lawyer, and as human being. Late Justice Sri Jagannadha Rao is survived by two daughters, Srimati Ratnamanjari and Srimati Ramadevi, and one son, Brother Justice Ramchandra Rao, Chief Justice of Jharkhand High Court. I, on my own behalf, as well as on behalf of brother and sister judges, as well as on behalf of entire judicial fraternity of Telangana, convey heartfelt condolences to the members of the bereaved family. May the noble soul find eternal peace at the feet of Almighty. As a mark of respect for the departed soul, we shall observe silence for 2 minutes. Work for rest of the day shall remain suspended.